Lords, if I may make a mention of one item number
Please
50.
button up your coat first. Please button up your coat first.
Where is it? Apologies, my lord.
Yes,
Apologies, my lord.
it's okay.
If I may make a mention, my lords, of one item number 15, WA number 2 of 2020.
Yes.
My lords, this matter was before this until this point of time has always been listed in code number 1. So I was under the impression that I'm an outstation counsel, my lord, from Mysore. So I was under the impression that the matter would be listed under code number 1, and I have come here today to make a mention, actually to make a mention before code number 2. But then it was only this morning that I heard that this matter has been listed before this court. So if this item may kindly be listed 2 weeks, if I may have a fixed date, my lord, after 2 weeks, my lord.
You're there?
Yes, sir, I have
You
not.
agree to a date, both of you?
Any date, Lordship, I have not. You suggested it.
15th or 16th of this month would be good, my lord.
Okay. Your name?
Lord Sami Masailo, my lord.
Okay.
Yes.
On the prayer made by Mr. El Sailul and counsel for the appellant, the matter stands adjourned today. Ms. P. Bhattacharya and additional AG is present for the state of Mizoram is present. Next para list on 15/5/2025. Please check the office note. What is it for? This matter has come with some office note. Just check it. Just check it. Check the records. Yes.
Yes, Lordship. I beg to mention item number 10, Lordship. Conducting counsel Mr. M. Hassan Anglo, Lordship. Lordship may kindly accept this after 2 weeks, Lordship.
Okay. Both sides are represented on the prayer made by learned counsel for the traditional. Rest after 2 weeks.
Which out?
Okay.
Okay.
Yes. Next.
Lordship, item number 12, I'm praying for adjournment.
Okay. I have same order. Item 12.
Lordship, kindly take up on Friday.
It goes after 2 weeks. Yes. Next. आपको motion हो जाओ.
Item 1 for motion.
Kindly 2 weeks granted for filing additional affidavit. Additional affidavit.
Billion lectures of permit rules.
SR does.
For, for admission, item 2, 3, and 4.
My lord, the government of the appellants were concluded, my lord, Mr. Dr. was continuing.
By the course.
Mr. Chaudhary, Mr. Sharma and Mr. Datta, since matter has been heard in piecemeal, list of books, please give again. Yes.
My lord, one a video was filed by us, my lord, in item number one. Item number 3, my lord, in 2 and 5. Now there we have given some certain decision already we have given, my lord, except one, that 1978 one SCC, Mahendra Singh Gill, that was not given there, my lord. Other day, my lord. Already,
Just write it in a piece of paper and give it to us because there's a tendency to forget.
no, it is in the in a video, my lord, we have given all this.
No. You see, when we dictate judgments at that point of time, we may not, we may overlook something which is printed in the affidavits. Please give a list of books to us separately.
Now, one thing I want to just point out, my lord.
This is just to ensure your interest, nothing more.
One thing just I want to, but they have been relying on IFA order, my lord, of 2002. In that they have shown, they have argued something, and my lord, their plea was it was Sikh industry throughout, and still it is a Sikh. Still it is a Sikh industry. But my lord, your lord, kindly come to my affidavit 242, page number 242. In the affidavit I filed on 10/3/2025. Mr. Bhuvan and Lord. और एक पॉइंट के लिए दी दिया तो बना ऐसा नहीं इस पर
In which item?
item माइनस 215 item 3 I think माइनस
15.
3 है ना 3
300.
माइनस
Page number
242
242.
last but
Yes.
one paragraph of the IFR order
Yes.
माइनस
Yes.
paragraph 5 of the order माइनस has a lot of bot माइनस
Yes.
is the net worth of BVCL after restructuring with 468.24 crore consisting of paid up share capital is substantially higher than its accumulated loss, including the inter-unit account. Rupees 157.72 crore. BBSL shall be now outside the purview of the SISA, Sikh industry. So it is no more a Sikh industry, my lord. At least after 2002, my lord, when it was taken over by the Barmutra Valley, my lord, it is no more a Sikh industry. That I point out, my lord. Rest decision, my lord, I have already given in this affidavit. Yet, my lord, we will give the list of books, my lord, so that lordships may find it easy to deal with. Rest, my lord, many things we have argued, and your lordship might have noted that the employees are, my lord, working, teachers are working for the last about 30 years now. And some of them are about 25 years. So it is serious exploitation, and they are still continuing, and they have already submitted before the court, my lord, that they are not going to terminate us also. But they are keeping it ad hoc. Advocacy for long 25 or 30 years is deprecated by any legal proposition, my lord, including the on the Supreme Court. And the single bench judgment, I pray, should be upheld, my lord. And the point that at the cost of reputation, my lord, that in the affidavit opposition in the, my lord, writ petition, they have not pleaded what they are pleading in the by way of additional affidavit in the writ appeal. Even the writ appeal, my lord, that does not contain any statement of what they are now pleading in additional affidavit. So that is barred, my lord. We have already cited some decisions of the Supreme Court also. You have to take the plea at the first instance so that we could deal with that, reply it, counter it. They didn't do. And in the writ appeal also, my lord, as it is, it was not there. The contents are totally different. There is no. They have brought in new facts, new my situations. So in that way, my lord, the writ appeal is liable to dismissed in limine, my lord, and the single judgment is upheld. Because after all, the employees, the petitioners are human beings, my lord, and they need fair treatment under any law, not only under labor law or the fair employment system. Protecting the interest of Article 21 and Article 19. And also though it is not strictly a part of fundamental rights, my lord, the directive principle is the policy, particularly that I had cited earlier, constitution here. Where the state shall try to ensure, my lord, that Article 38, 39 of the directive principle is the policy, my lord. And 41. 43. Our living wages and in the costly days of today, with the hiking prices, my lord, it is not possible for a human being to maintain his family, take the liability of medical and education expenses. So, my lord, rest, my lord, we have already submitted and also contained in our reply counter as well as the additional affidavits we have filed. That's my submission. And in the Mahendra Singh Gill case, 1971, it says, your lordship knows, my lord, what is there in the record cannot be improved by your affidavit, or far less the additional affidavit. My lord, having said so, my lord, I conclude my argument, my lord, and it is the turn of Mr. C.C. Datta. Okay. My lord, may I request that I be allowed to leave? He is there. He is equally more competent.
I don't know, because at times, when I don't think straight, I find that if it is something to deal with revenue management, better you can both talk outside.
Revenue management, your lordship is well versed, not we. But my lord, your lordship has kept this.
I'm trying to show all of you that I am also old now.
No, my lord. Today we are talking in the chamber business been here. I was asking why
Because I have crossed my first footsteps of becoming old because I have recently had a cataract operation. So I've reached the first footstep.
My
of
lord,
becoming
that-
old.
That is not the qualification, my lord, to be old.
I don't know. I thought
Nowadays, my lord, there is a my lord, World Health Organization report I had seen one about 3 years back. 18 to 65 is young. 65 to 79 is
no,
middle aged.
there's something else. You are absolutely right. I'm not disputing what you are
Yes.
saying. But since I talk more, I have a tendency to say few, make some loose statements. And therefore, to instill confidence on all of you that I am old, I have grayed a bit. I'm just keeping it.
Because you are talking loose, you are bit my lord, laughing or smiling. That shows that you are tension free, and that is the reason why a man remains young. Obliged, my lord.
Many things to learn from you.
My lord.
Many things to learn from you.
Yes, I'm still in 70, my lord.
I am aware of it.
But I'm yes, as young as 40 years.
My lord, in fact, we have concluded our argument. But then just a few things I want to highlight for your lordships. I will take your lordships, my lord, read appeal number 242, item number 2, my lord. If your lordship recollect the argument, my lord, on behalf of by Mr. Chaudhary. Now, your lordship will find they want to say by filing an affidavit that the school was never undertaken by the new organization. Now, how far that is correct, your lordship will find that before the read code, they made certain things, and now they are shifting from that. It's quite a somersault your lordship can presume. Now, if your lordship look at in page 92, there is the affidavit file in the read code. What is their stand?
That
As-
you have already indicated, paragraph
Yes,
9. you had-
I just want to say that, my lord, is just a contradictory stand in the affidavit, whether it can be accepted. Apart from that, my lord, they are saying, my lord, they are not denying that the sanction post of 117 teachers were there. They are only saying the records are not available. So therefore, your lordship may kindly see at page 92, paragraph 9. Read it, please.
Page number.
Very, 242, item 2. Now, my lord, I am reading slowly, para 9, that while denying the correctness of the averments made in paragraph 4 of the petition, your humble answering deponent states that the claim of the petitioner that as per record in 1991, the total sanction strength of the school was 134, where 117 numbers of sanction posts were for teachers and 17 numbers were for teachers PS. No such record is available. The government is that no such record is available. They are not denying it. At present, as per the report submitted by National Productivity Council, there are only 2 regular posts. Now kindly, your lordship kindly see, in order to evaluate their evidence, I mean pleading, something in the read petition and in the read appeal, and from where they are shifting by filing an affidavit. Here it's an admission that school was there and there was 2 regular posts they want to say. Only 2 regular posts, one is of the principal of grade E3 and the other is of the vice principal of grade E2. And a total number of 28 senior teacher on ad hoc contractual basis. Further, the documents annexed as annexed 2 without any seal and signature in the read petition are also doubtful, inasmuch as no record is available in the complaint. Only thing they want to say that 117 sanction post, my lord, they want to say this is doubtful because the record is not available. It's not that sanction posts are not there, they are not denying it. Furthermore, now the stand, my lord, nowhere in the read petition or in the read appeal, they ever taken that reading that in fact there was no, well, the school was never undertaken by the new organization. Only, and this is, my lord, the stand is contradictory in the sense, your lordship will find that here they are saying there are 2 regular posts of the principal and vice principal. Now admitting that the school was undertaken. Now this is, my lord, I don't like to repeat all that. So therefore, my lord, the submission made by them that the school was never undertaken by the new organization crumbles for that reason only. Therefore, my lord, it is all their turn where it was their duty to prove that whether the school was undertaken or not. Now, we cannot be asked to prove the negative, my lord. And my lord, at the cost of repetition, I would like to take your lordship at paragraph 242. My learned friend, Mr. Sharma, has already pointed out that. My lord, I'm just reading that paragraph 5. Already Mr. Sharma has, my lord, taken to your lordship's paragraph at page 242. There's the additional affidavit filed by Mr. Sharma.
242 in which read petition? This read
That is
petition doesn't have
WA 215.
215. He just read.
Yes,
Mr.
your
Sharma
your
just
lordship
read,
has seen that. My lord, that's okay. Then the last para, my lord, 244. Your lordship will find the provision for maintenance of schools and education that are kept there. page 244 in the schedule, my lord, your lordship will find.
Yes.
Schedule 12. Column 3, your lordship will find maintenance of school and education facilities. The total 1,11,410. That provision was kept. These are not required to be looked into in the sense, this was not pleading, this was not their pleading. And then, my lord, against the additional affidavit, we have filed our reply also. That your lordship will find in page, starting from page 192.
192, which read petition?
This is writ appeal 242, my lord. Lord, I am not reading those paragraphs, your lordship.
Page,
May-
page number
Page number 190,
190.
192, my lord.
Yes.
Lord, then we have already stated all that. My lord, in paragraph 5, your lordship may see at paragraph page 194. The last few lines, my lord. In reply to that, from bottom 1, 2, 3, 4, 5 lines, my lord. Page 194.
Yes.
There your lordship will find in reply to that, the deponent would like to state that whenever an organization is taken up or merged with a new organization, the assets along with all liabilities are invariably taken over by the new organization. And in the instant case, the order passed by the appellate authority dated so and so clearly indicates that the BVFCL, while taking over so and so, undertook all the assets and liabilities of the Hindustan Fertilizers Corporation Limited. Furthermore, the statements in paragraph 3 stating that under the established principles of corporate restructuring, a demerger necessitates transfer of only those assets which are essential for independent functioning of the resulting entity, and education institutions being welfare measures are not considered to be core business assets of such purposes, and this is utterly false statement. And the person swearing this false affidavit is necessary to be taken to task in accordance with the law. In regard to that, my lord, we have already, my lord, cited one decision that, my lord, we shall furthermore, this question, we shall, in the list of the books, once again, we shall give it to you. Then, my lord, your lordship may say, paragraph 6. But I don't want to read it. I have already read. Only thing I'll take your lordships to page 208, two letters which are very important. 208 and 209. 208, your lordship will find is a letter dated 29/9/2020. For administrative convenience, Sri Dilip Kumar Singh, senior teacher, is hereby authorized to sign all documents as principal in charge, EVFCL.
This,
Which
Mr.
is-
Datta, last time we pointed out
My lord,
in the affidavit which you have read of the respondent,
my lord.
there you will find reference to the existence of the 242 you read, the affidavit.
Yes.
In that, there is a reference to the existence of post of principal and vice principal
My lord.
and 28 senior teachers
Yes,
that they have admitted there.
right,
So if there is a reference in this page 200, 209,
my lord,
208, 209 about those persons who are already in the affidavit.
yes.
And
I
last
think-
time also we pointed out, you'll have to
Right,
show us that this is false projection.
My lord, what I want to project, my lord, they, in the read petition, your lordship will find, they never stated that this school was never undertaken by the new organization. Even in the read appeal also, they did not say all these things. So those were not, since it was not the pleading, my lord, we did not have any chance to rebut that. So therefore, my lord, just in the read appellate court, they filed an affidavit stating that the school was not taken. Now, it is totally their burden when they say that. So with that idea, my lord, I am, my lord, highlighting all
Last
these.
time we took note of that. That's
My-
why I
So
recollected
therefore,
that
my lord,
question.
We have given the reply to that. And now, my lord, your lordship is well aware of that judgment. My lord, last time we could not give it to your lordships, that Mahinder Singh Gill, just I will read paragraph 8, my lord. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reason so mentioned and cannot be supplemented by fresh reason in the shape of affidavit or otherwise. My lord, now this is also a statutory organization. It was their duty, my lord, to give up the clean thing so that, my lord, court can adjudicate the matter and come to a correct finding. Now here, my lord, you don't say anything in the writ court. You did not say anything in the writ appellate court. Now you file an affidavit. Now, as a result, what happens, my lord? If you give it in the affidavit, there is no chance to rebut it. We have rebutted. But then in order to scrutinize all that thing, my lord, again, your lordship will have to go into all these things. Is not necessary at all in the sense, because it is not your pleading. And we have, the last occasion, my lord, we have cited certain decision of the appeals court, where, my lord, the appeals court has clarified, and by this honorable court also, because if you don't plead anything, but the court will not go into it. And that law is, your lordship is well aware, as is already crystallized by the many decisions of the appeals court. And my lord, the decision which your lordship has said, that we are to give a fresh list of this decision of the courts. My lord, we shall be furnishing to your lordships, just after some time. My lord, with this I will conclude. Your lordship, only thing your lordship will say, these people have been working, most of the persons have been working more than 25 years. So for this Bornali is concerned, she has completed more than 30 years, more than 30 years. Now therefore, my lord,
We
when,
last time requested you to give a list of persons who have been working how many years?
yes,
Have you given that list?
that I think it will be housing. Huh? I think, my lord, I told my
No,
junior
I
colleague.
don't know because I have not gone,
Anyway,
I have
I'll-
not rechecked.
If it is not there, my lord, I'll
Mhm.
give you a fresh one. And-
Just recheck it. We'll send it, after Mr. Chaudhary completes, we'll give the record. We'll just
Yes,
check it.
yes. It is ready with me, my lord.
That's okay.
I can furnish. to
It's
you.
okay.
With this, my lord, I come. Yes, I will. Oh, okay.
My lord, I'll be very brief in my reply. My lord, your lordship has already given enough time to both the parties, my lord, to place their case. Now, my lord, so far the my lord, submissions made to their concern that those made by my learned friend Mr. Sharma and also Mr. Datta revolves around, my lord, the affidavit that has been filed, additional affidavit that has been filed on 24/1/2025. Their submission is that we have made out a new case, which has not pleaded in the writ petition, even not in the writ appeal. And therefore, this cannot be, perhaps, my lord, taken note of. Now, my lord, in that respect, I'd like to draw your lordship attention to the order passed by this court on 11/12/2024. That will be very vital, my lord.
24,
11/12/2024.
11, 12, 24.
If your lordship permits, my lord, I will read the entire order. Not a
Yes.
very long one. Has your lordship got it? Writ appeal 242 and 233 are preferred on behalf of the appellant, the Brahmaputra Valley Fertilizer Corporation Limited, being aggrieved with the impugned order 19/6/2024 passed by the learned single judge in WPC so and so. And writ appeal 215 is preferred by appellant corporation, being aggrieved with the order dated 23/4/2024 passed by the learned single judge in WPC 7253 of 19. While the order dated 23/4/2024 passed in WPC 7253 of 19, the learned single judge has directed the appellant corporation to regularize the services of the teachers working in Brahmaputra Valley Fertilizer Higher Secondary School for the from last 30 years. Similarly, while the order dated 19/6/2024 passed in WPC 6015 of 23 and 6558 of 23, the learned single judge, while taking into consideration the order dated 23/4/2024 passed in WPC 7253 of 19, directed the appellants to regularize the services of the teachers of the Brahmaputra Valley Corporation Limited. The appellant corporation is claiming that the liability of the aforesaid school was not fastened upon the appellant corporation. This court, while the order dated 17/7/24, had granted time to the learned counsel for the appellants to satisfy that at the time of taking over Hindustan Fertilizer Corporation Limited by the appellant corporation, the liability of the school run by HFCL was not fastened upon the appellant corporation. Learned counsel for the appellant corporation has placed on record an order dated 26/4/2002 passed by the appellate authority for industrial and financial reconstruction, New Delhi, and has contended that the appellant corporation has taken over only Namrup Unit 1, 2, and 3 of the HFCL on its demerger. It is contended that the school in question was not falling in either of the units which were taken over by the appellant corporation. Learned counsel appearing for the appellant corporation is directed to file an additional affidavit of this effect by the next date of hearing, along with the documentary evidence that the liability of the school in question was not fastened upon it within a period of 3 weeks from today. The copy of the said additional affidavit be supplied to the learned counsel for the respondents in advance, who may file their response if these are so within a further period of 2 weeks. In the meantime, the effective operation of the impugned order so and so is, my lord, remains still. Now, my lord, this affidavit has been filed on a direction by this honorable court, and they have been given opportunity of rebutting that. And this question has been put by this honorable court in order to ascertain the factual position, and accordingly we have filed the additional affidavit. Your lordship has read the affidavit and my lord, the order of the appellate authority. I will not go into that. Therefore, my lord, filing of the additional affidavit cannot be questioned by them. This is as per the direction of this honorable court to find out the issues in controversy, to determine the issues in controversy between the parties. Now, my lord, regarding the sanction post, my learned friend Mr. Datta was referring to page 92, paragraph 9, regarding denial, my lord. If your lordship has already noted down that, my lord, we have stated that the post of vice principal and vice principal, those are sanctioned posts, and a few number of posts were there. That has been admitted. But the document they are relying to show that certain number of posts are vacant, they're relying on a document which is not signed by any authority. And that is where the denial is. That document your lordship will find at page 54 of writ appeal 242. Page 54. Page 54, your lordship will find this is a Hindustan Fertilizer Corporation's order. This is not a signed order. And the document annexed therewith has also not been signed. Therefore, my lord, this is a document which cannot be taken cognizance by this honorable court. Now, my lord, the question that falls for consideration in my humble submission before your lordships is that, my lord, whether, because I'm not going into the facts again, my lord, I don't want to elaborate on that. Your lordship has already heard at length and also, my lord, taken notes thereof. The question is whether a direction can be issued for a regulation of service. For that, my lord, in this case, I'm relying on only two judgments. One is, my lord, Uma Devi. That is, my lord, 2006, volume 4 SCC, Uma Devi 3, SCC 1. Relevant paragraphs, paragraph 43 and 53. Your lordship will kindly take note of the date of the judgment, my paragraphs 43 and 53. The
Yes.
date of the judgment will be important, my lord. This was rendered on 10/4/2006. The law has been laid down that those persons who have been serving for a period of more than 10 years without any, my lord, interference of the court, my lord, stay or the record, their services should be regularized by framing a scheme as a one-time measure. So, my lord, it is not a direct direction to regularize them. The direction is that those who have completed more than 10 years for regularizing their services, the state has to formulate a scheme. Now, this judgment, my lord, applies to persons who have completed 10 years or more on or before 10/4/2006. Now, so far as my lord, the three appeals are concerned, your lordship will find, my lord, the item number 2 and 4, writ appeal 242 and 233, they are, my lord, similarly situated. 242 and 215. Please, the third person. The first person.
Please elaborate. We did not get it. Please elaborate. We did not get it.
My lord, what I mean to say is that your lordship will have to consider the dates of appointment of these persons for the purpose of, my lord, the getting the benefit or lack of it, my lord, of Uma Devi's case.
Okay, you are trying to say that this 242 and 215,
Yes, my lord.
all those who had served did not have 10 years of service as on 10/4/2006.
My lord, that is in respect of, my lord, that Purobi Lahon's case, that is 233 of 2024. In this case, my lord, all the petitioners were appointed after Uma Devi's case, except one person. Except one person. In your case, no. All the persons have been appointed after the judgment of judgment in Uma Devi's case. That is in my lord 233. I think there are my lord 12 petitioners. Therefore, they cannot get the benefit of the judgment of Uma Devi's case. So far as the my lord other two appeals are concerned, they were appointed or engaged, my lord. Well, I will not call it appointment, my lord. They were engaged because, my lord, there were artificial breaks in between also that your lordship has already taken note of. So in respect of them, the only relief perhaps the court can grant is that the court may direct the authorities, I mean the corporation, to frame a scheme. And this position is, my lord, clarified in another case, 2017 volume 3 SCC 410, State of JK versus District Bar Association. This is a, my lord, 3-judge bench case. 2017 volume 3 SCC 410. The 2017 volume 3 SCC page 410.
Yes.
The relevant paragraphs will be 11, 22, 26 and 30. In paragraph 26, my lord, the law has been explained. May I
What has
read
been
that?
laid down in para 26?
May I read it, my lord? May I
Yes,
give a
the
copy?
relevant part.
Other paragraphs I will not read, my lord. Paragraph 26 only I will read.
That's it.
Yes.
SCC.
I will ask you. As a copy of
Oh, acha. Okay, we have got it. We can move.
I'm sorry, my lord, I have only one
It's okay.
printout extra, my lord. The principles will have to be formulated bearing in mind the position set out in the above judgments. Many judgments have been discussed, including Uma Devi. The regulation is not a source of recruitment, nor it is intended to confer permanency upon appointments which have been made without following the due process envisaged by Articles 14 and 16 of the Constitution of India. Essentially, a scheme for regularization, in order to be held to be legally valid, must be one which is aimed at validating certain irregular appointments which may have come to be made in genuine and legitimate administrative exigencies. In all such cases, it may be left open to the court to lift the veil to inquire whether this scheme is aimed at achieving the above objective and is a genuine attempt at validating irregular appointments. The state and its instrumentalities cannot be permitted to use this window to validate illegal appointments. The second rider which must necessarily be placed is that the principle as formulated above is not meant to create or invest in a temporary or ad hoc employee the right to seek a writ commanding the state to frame a scheme for regularization. Otherwise, this would simply reinvigorate a class of claim which has been shut out permanently by Uma Devi 3. Ultimately, it would have to be left to the state and its instrumentalities to consider whether the circumstances warrant such a scheme being formulated. The formulation of such a scheme cannot be accorded the status of an enforceable right. It would perhaps be prudent to leave it to the claimant to establish whether he or she falls within the exceptions carved out in paragraph 53 and falls within the ambit of a scheme that may be formulated by the state. Subject to the riders referred to above, a scheme of regularization could fall within the permissible limit of Uma Devi 3 and be upheld. Therefore, my lord, my humble submission is that in view of this law laid down, my lord, perhaps the only relief that can be given to these two, my lord, writ appeals, not the third one, where, my lord, they were appointed subsequent to Uma Devi, is that the court may direct the, my lord, corporation to consider framing a scheme. This is the long and short of the case, my lord.
That is the precise question we asked on the first date. Can we make the post personal to them till they superannuate? That was the query posed.
But the, my lord, the law is very clear, my lord, Uma Devi and this judgment, three judges bench, my lord. So in one case, my lord, no relief can be granted. In the other two cases, my lord, perhaps your lordship may, if your lordship, my lord, thinks it proper, then, my lord, direct the authorities to consider framing of a scheme. This is my submission. Mr. Sharma has a, my lord, I appear for the item number 2 and 4. Mr. Sharma appears for item number 3.
Nothing more to add. I'll adopt my senior's argument. Only one aspect regarding the date. Regarding Uma Devi's benefit, if it can come before, so in writ appeal 215 where I'm appearing, respondent number 3, Himanta Dora. His appointment is 3/6/1996. So therefore, he did not met the 10 years requirement when the Uma Devi judgment was passed on 10/4/2006.
You are in 2-1.
215, writ appeal
215.
215. Item number 3 also. The other two employees, they would be covered because they were appointed in 94 and 94. Respondent number 3, Himanta Dora. 3/6/1996. That's the only thing I wanted to.
Aarti was appointed on
On 3/6/1996. And Uma Devi's judgment was 10/4/2006. So he fails by 2 months. Also. The rest I adopt my senior's argument. Obliged.
the submissions of Mr. R.P. Sharma, the senior counsel.
My lord, just for a minute, my lord, so far, the order dated 11/12. My lord, I just want to say one line from there. Learned friend made an argument that by virtue of order dated 11/12/2024, they have been given a chance to substantiate whether they have done so.
Learned
We'll also
senior
look
counsel
at the
assisted
order
by
dated
Mr.
11/12/2024.
Ms. M. Chengmai,
in
learned
para
counsel for the private respondent in WA 215 of 2024 is concluded. The reply submissions by Mr. S. Dattar and its senior counsel assisted by Mr. S. Dingia, learned counsel for the private respondents in WA 242 of 2024 and WA 233 of 2022 is concluded. Reply submissions by Mr. M. P. Chaudhary, learned senior counsel assisted by Mr. B. Sharma, learned counsel in WA 242 of 2024 and WA 233 of 2024 is concluded. Submissions of Mr. The reply submissions of Mr. A. Sharma, learned counsel for WA 215 of 2024 is also concluded. So judgment reserved. Yes, what do you want to
My
say?
lord,
That,
your lordship kindly see the order dated 11/12/2024.
yes,
What your lordship has said from last, my lord, it will be third para from the last. Learned counsel appearing for the appellant corporation is directed to file an additional affidavit of this effect by the next date of hearing, along with the documentary evidence that the liability of the school in question was not fastened upon it. Now, what documents they have furnished? Nothing. So therefore, it is not that this honorable court has asked them to file an affidavit and it has given them a right. Unless you can link with that, that school was never taken up. If it is taken, then there will be a list, and the list will show that the school was discarded. Now, where are those documents, ma'am? And now, my lord, regarding REIT Appeal 233, your lordship will find 3 persons, they did not complete 10 years. Your lordship look at REIT Appeal 233, petitioner number 9, 10, 11, 12. This is the 4 person, my lord, they did not complete 10 years. So, my lord, I don't want to make any argument on their behalf, saying that
Please repeat again, respondent numbers. in
respondent number
WA,
9,
WA number,
WA number 233 of 2024.
respondent
Petitioner,
number,
number 9, my lord, Simi Mohan. Then number 10, Niranjan Kaklari. Then 11, Parinita Boklial. Number 12, Sonali Nandia. These are the 4 person, my lord, they did not complete. My lord, I will give the list.
we are just sending you this 3 files.
My lord,
Kindly check up.
my lord, I will do it. And regarding, my lord, 10 years of completion, as your lordship is well aware, the state of Karnataka versus ML Kestis case, if once completed 10 years of service, and if it is in terms of para 53 of the my lord Umadevi's case, lord, they can be regularized.
My lord, I need to give a reply to that. My lord, my submission was not that they have not completed 10 years of service. What I submitted is that after Umadevi's judgment, you cannot get the benefit of Umadevi, whatever.
The
year
only
number-
thing is that good things must come to an end.
No, my lord, since he has given a reply, so my lord, I need to give the clarification. My lord. That was not my argument, that they have not completed 10 years. What I say is that after Umadevi's case, they cannot get this benefit.
Yes. We have already dictated the order in the meanwhile. We've dictated the order in the meantime. But just make sure we are sending you the files. Please
Well-
see that if list of dates, list of books are not there, please supplement that.
We're relying only on those 2 cases.
Yes.
All right.
এইটো খুলি পেলাই একলগত কৰি দিয়ক হা, নহলে বেলেগ বেলেগ পিন থাকে বহুত কেইটা।
Supplementary item 37 upgraded for admission.
57. It was taken up yesterday, no?
The same matter, because half order we dictated, then we found out that the explanation of delay.
It's not that okay.
The second is that I don't know whether you will remember it or not, but the case projected was that the petitioner had gone to her husband, who's living with his second wife.
Yes.
He's a resident of Borpeta. He went to Mangaldaid, where the husband was living with second wife,
Second one.
and then he took the papers and did not take any action, and therefore the delay. But while halfway dictating the order, we found out this page 12 is the affidavit here. That you may not be getting there. Page 12 is the affidavit. With the signature, I got an impression that he must have been an educated person, because otherwise
There
It's
is
an,
writing.
the handwriting is good.
Hmm.
So that is somehow, I don't know, I did caught my eyes, and then we thought that he may be educated. So the question was that if the son of the petitioner is a person who is 25 years of age, and then he goes to the husband who gives the documents and they don't do anything. That's why we thought we would have to rehear it again. Because he's behind the bars since
December
10, 12, 21. That is, yesterday we were told.
24.
24 now.
22. 3 months.
So that was the consideration. We thought that we would hear the matter, since the records are already here. We will hear the matter. It was an ex parte opinion rendered.
Do you want to start with the hearing now?
Yes, he'll address us. Then
Yes,
we'll-
Lord.
So it is admitted that the notice was duly served, Lordship. Even from the LCR also, I have found that she has signed that and she has kept the notice. The process server's report is also there. And it is also mentioned in the paragraph number 2 of the order, Lordship, that it is mentioned that OP was asked to appear in person or by her engaged counsel by notice dated 4/4/23 before the tribunal on 15/5/23. That means on 4/4 the notice was issued and she was asked to appear on 15/5, Lordship. But on the said date, neither OP nor her counsel appeared. However, another date was fixed for appearance, fixing 22/5/23, but none was present, and again on 22/5, as a result of which it was fixed for ex parte order to be delivered on 35. And so by 35, Lordship, that ex parte order was passed, Lordship. Other part, Lordship, since the order was not on merit, Lordship, I humbly pray that she, as per the documents so far she has provided to me, Lordship, which I have annexed, she says that her grandfather, Lordship, is one. I've made a statement, Lordship, because the grandfather's name. Father's name is actually Lukman, Lordship. It's Lakshan Mia, written in the voter list of 1966. Hamid Mia, who is also the son, and Halemon Nessa. These are the 3 voters. And these 3, as per the petitioner, are her grandfather, paternal uncle, and her grandmother lordship. Page 20 is the translated copy lordship and the vernacular is at page 21. Then page 22 is also the 1970 voter list lordship. The name of these three persons again appeared lordship. And the village lordship will see. Village is Komalpur Colony here, village, and Borbola in the 70 voter list. And 85 lordship, next voter list is the 85 voter list lordship, which is of Borbola lordship, where the petitioner's father's name is dear lordship. Son of Lakshan. Hazrat Ali is the father of the petitioner lordship as per, and Asatan Nesa is her mother lordship. And these two persons' name appeared in the voter list of 1985 of village Borbola lordship. And 80,
This, just a moment.
yes, lordship. The
Page
age
21, you are showing that these are the
grandparents,
father,
grandparents,
it's a grandfather.
grandfather, grandmother, and one paternal uncle lordship.
Okay. Lakshan Mia is the grandfather.
Yes, actually his name is Lokman Mia lordship. I have made a statement, but here it is Lakshan recorded.
Okay. Hamid,
And other one is page 22
that Hamid,
is
Hamid Mia is who? Uncle.
uncle lordship,
And Holimon Nessa,
is the grandmother.
yes.
Then in 85 voter list, her father's name is dear chief. He has given a voter list of 85, which shows that Hazrat Ali is her father, who is the son. Here also the grandfather's name appeared as Lakshan. But village lordship will see Borbala, and 70 also it is Borbala lordship. And 89 lordship is the another voter list of her father lordship. It is also village Borbala. Here lordship, the grandfather's name now appeared as Lukman. And Asatun Nesa mother Hazrat, and Sohidul Islam is her brother lordship. Then 2005 and 2010, other brothers also appeared lordship along with her parents. And up to 18, she has given the voter list up to 18 lordship. And
Father's first time name appears in 80.
exactly not, it's not, maybe not be the first voter list, but she has given this voter list of 85,
But then.
but the age is there 40 years. I mean to say.
Please come again. This page 24, 25. Hazrat Ali is the father
Father lordship,
and Satan Nessa is the mother.
mother lordship.
विलेज सब बदली हो जाएगी also no continuity, 40 years of first.
89 Lordship, then father, mother, and her brother Lordship.
Which page are you referring to?
Page 26, 27,
27.
27.
And the next one, 29. Who are these two? Moinul and Shakil.
29,
Who is Moinul and Shakil? Page 29.
29. Asaton Nesa,
No, no, last two names.
Moinul Haq and Sikimuddin.
Who are they?
They are the brothers, son of Hazrat Ali.
Where is Shohidul? Shohidul's name is not there. The one you're referring to at 27.
27, his name is there, but
Who's missing here? After that, he's missing all three.
maybe he got separated from the family.
That's what he meant. अभी तो हजरत आ गई।
And Lordship, Annexer 2, Lordship, is a transfer certificate where the father is shown as Hazrat Ali, Lordship.
Yes.
So these are the documents, Lordship. Apart from that, after her marriage, her name was also recorded in the voter list along with her husband, Lordship. And in
What is the first, which year is the first voter list of the petitioner?
petitioner is the 93, Lordship.
93.
Hmm. It is recorded as Mazeda Khatun, wife of Akbar Ali. Age 21 years. Page 36, Lordship.
But first voter list is 1993.
Yes, Lordship.
Which page?
Age 36.
36.
37 will be the names are there in 37.
By 93, 21 years, the constitution was supply. 21 years.
Ms. Verma,
Yes,
in view of the ex parte opinion, why it should not be sent back?
no. What is lordship notice was served, she received it herself. This is what I gather from the opinion. And her plea that the husband took away the notice, husband is not made a party here, lordship. He ought to have been made a party. It was very much in her knowledge that there is a case pending against her because it's a matter of 2017. So the inquiry must have been conducted and she's aware of it, lordship. IMDT reference, IMDT. 2002 lordship. It's a IMDT reference of 2002. Case was registered in 17. Cannot take the plea that I was not aware of the proceedings. I never appeared before the inquiry committee or no inquiry was held. Lordship. On this first issue only, I would like to rely on one judgment, lordship. And then again, lordship, if lordship comes 66 and 70 documents after that, there is no continuity of the stay of the grandparents. Then they come to the 1980 document, 80s voter list. After 80, 85, 89, and the her name and even the siblings' name disappear after a certain point. Lordship will come to voters list of the if lordship comes to the even there's a change of village in 66 voters list. If lordship sees the name of the grandfather, Lakshan Mia is 55 years. And
You're referring to which page?
page 20, lordship.
Yes.
So lordship will see in 66, the grandfather, his age is 55. And in 70, his age becomes 49. There is a major discrepancy. First discrepancy is that, lordship. And the father, the projected father, Hamid Mia. And mother's name is there. Hamid Mia
No,
is the
no.
father.
Paternal.
Paternal uncle, okay. And Haliman Nessa is the grandmother.
Lordship, I'm sorry, Lordship, this translation, there is a mistake in the age, Lordship. It is 70, it's 59, Lordship. Vernacular is there. Page 23. It should be 5, Lordship. They wrote 4. Translation.
Okay. So, after the 66 and 70 voters list, lordship, even if my friend corrects that, there is no continuity of their stay, no continuous stay is not proved. Then the voters list, which is annexes of 1985 lordship, and the village changes. No explanation of the village changes. Shifting is not explained, lordship. The father and the mother's thing. Here the father's age again, the father's age is again changed, lordship. It becomes 40, Hazrat Ali. The father's name is not there with the his father. If 66 and 70 is voters list do not show, lordship, but Hazrat Ali's name is shown with some Lakshan and he's 40 years old. His first time his name appears is in 1985 at the age of 40 years. There is no explanation to this also, lordship. He ought to have at least 2, 3 more voters list prior to this 1985 voter list. And no explanation about the change shifting of the village. Then 80,
Just a moment, you are saying that there is no voter list showing the name of the father with the grandfather. That's what you are saying.
Yes.
Okay.
Grandfather's is with his father and grandmother with the husband, but no voters list to show. If he's 40 years old, his name ought to have been there with his father lordship in some voters list. And then 89 voters list, the third brother, like the third sibling, Shohidul Islam. His name does not appear again in any of the voters list with the parents, though he is the son of Hazrat Ali Lordship. But two new names appear on page 29, the voters list of 2005. After 89, again, there is no continuity. 2005 voters list come, no voters list of the 90s, nothing Lordship. Two new brothers appear, Moinul and Shakim. And the name of the third sibling Lordship, whose name figures in the 89 voters list, is missing here. And Lordship will again, the voters list do not match with the thing. And then continuous voters list of the family, but the daughter's name, petitioner's name does not figure anywhere with the family. And there's no explanation. of that.
Just a moment. No, it will go, it will be very important. Ms. Verma, we'll take a short break and come back.
Yes, Lordship. Lordship, after the voters list is relying on the Gaobura certificate that has been obtained only after the impugned opinion was passed. And there is nothing, no linkage of the proceeding with her father and the father with the grandfather. Not a single document to show that she is the daughter of Hazrat Ali and Hazrat Ali's father. The complete chain is missing, Lordship. And with these documents, she's not been able to prove her linkage at all, Lordship. Neither she, neither the father with the grandfather. Picking up and producing documents just with the name Lordship, that does not help to show this, that the grandfather and the father were related. Lordship, there is another thing. Akbar Ali's, maybe she is Akbar Ali's, the husband's second wife, is it right?
First wife.
First wife, because there are two women whose names figure with Akbar Ali.
Which page?
Page 37, Lordship. Akbar Ali is the son of Jumuruddin, and then Khudeja Begum is again with Akbar. Now, who is Khudeja Begum? He is not explained. Khudeja Begum's age is 26, so she must be the first wife and Rosidi must be the second wife. There are many things which are not explained, which are just left like this. Then Akbar Ali, again with Jumur Ali. Akbar Ali's name figures twice. Now one is with Jumuruddin and one is with Jumur Ali. There's no explanation to this also, Lordship.
You see, one is Akbar Ali and one is Akbar Ali. Let's say they are brothers. Petitioner's husband is Akbar Ali, and this Akbar Ali is the elder brother. And that Khudeza is his wife. His second wife's name is not reflected here. Akbar and Akbar in the same photo.
Okay. Yes. You have an explanation.
Lordship, I would like to rely on 2-3 judgments, Lordship. Firstly, the linkage is not proved at all. There is no documents to show that she is the daughter of Akbar thing, Hazrat Ali, Lordship. Not a single document to show her with her siblings or with her father or mother. Not a single voters list, not a single mention anywhere that she is so-and-so's daughter, so-and-so's sister. He's relied on 3 brothers. One brother's name disappears from the preceding voters list, Lordship. Nothing to show on record that she is the daughter of Hazrat Ali or sister of so-and-so. And the Gaon Bura certificate, which is relying on now, Lordship, this has been obtained only after the impugned opinion was passed. And this will not help because they have known about the proceedings right from the beginning. It's a IMDT reference, Lordship. And they have slept over their rights right from the beginning. So one paragraph, Lordship, I would like to rely on from one of the judgments of passed in this court, Lordship. It is Ayub Ali, Lordship. Muhammad Ayub Ali and others, writ appeal number 186 of 2015, reported in Lordship 2016 1 GLT 273.
2016,
1 GLT 273.
273.
Yes, Lordship.
Yes.
Paragraph 16, Lordship. Paragraph 16 says, principles of natural justice cannot be put into a straitjacket formula. It is more than 3 decades that the issue of influx of foreign nationals has been in public domain in the state of Assam. Process of determination of question of citizenship cannot be a one-way traffic leaning only in favor of a person whose citizenship is doubted. Interest of the state is also of paramount importance in that unabated influx has the potential to affect the integrity and sovereignty of the country. Citizenship of a person, no doubt, is a very valuable right and should be zealously guarded. However, if a person does not take steps for safeguarding his interests, he does so at his own peril. Right to a fair hearing or principles of natural justice cannot be permitted to lead to a farcical situation and to be an engine for defeating the very object of identification and deportation of foreigners. The petitioners had known about the allegations against them that they are foreigners entering India without any valid documents, at least from 2007, even ignoring the earlier part under the IMDT Act from 1997. The petitioners all these years apparently did not take any steps to defend their rights in the court proceedings. In the circumstances, I am not inclined to grant any further opportunity to the petitioners as any such course of action, according to the perception to the court, would be self-defeating. There is no such plea that the impugned order was not known or something, but the lady herself knew
No, but
that there is a proceeding.
this judgment is not for the proposition to set aside an ex parte opinion. This was a contested application. This
Ex,
2016,
Lordship.
one GLT. But
Yes.
here, Mr. Ahmed is praying for setting aside the opinion because it's an ex parte opinion.
Yes, Lordship. Lordship, even in her case, she accepted the notice. Sufficient opportunities were granted to her. Continuous default thereafter, court waited and court gave her enough time to appear. When she did not appear, only after that the ex parte opinion was passed. And that is reflected, for that Lordship, I would like to rely on Sarijan Nesa versus Union of India. It was WPC 1293 of 2020, decided on 5/1/2021.
Please give the name and case number again.
WPC
Name
1293.
of the parties.
Name of the party Sarijan Nesa, Sarijan.
Sarjan Nesa,
NESSA. It
Yes.
was
WPC
1293
of
of 2020, decided on 5/1/2021.
Yes.
So, Lordship, in this, Lordship, another, I will come to the proposition in this. In this, the proposition is sufficient opportunities were granted, continuous default thereafter, and only after giving adequate opportunity to the petitioner to the proceedee to appear. When she did not appear, the ex parte order was passed. And that was keeping in mind, Lordship, Order 3(8) of the Foreigners Tribunal. The FT shall give the proceedee 10 days time to give reply to the show cause notice and further 10 days time to produce evidence in support. So it is not that opportunity was not granted to her. If Lordship will go by it, sorry, and then Lordship, it cannot be an endless proceeding. For endless proceedings, I am relying on Lordship. WPC 8361 2019, decided on 12/10/2020. Ijjat Ali versus Union of India, Lordship.
spelling.
IJJAT, Ijjat Ali, ALI.
Yes.
Then Lordship, one more I would like to rely on. WPC. It was 82 asile na 821 asile. But in Paramount. 82 of 2024, Lordship.
WPC
82 of 2024.
Yes.
Are decided on, Lordship, I'll give the date. I will just, then Lordship, one more I would like to rely on is WPC 291 of 2024, decided on 23/2/2024, Baharul Islam. This one judgment of Baharul Islam, Lordship, it covers all the aspects and issues taken up in ex parte orders. I'm just coming to that, Lordship. Itu Baharul, na? Itu Baharul, na? Lordship, I would like to rely on one more judgment where ex parte orders
No,
can.
in these two cases you are citing this,
Yes, Lordship.
this 82 or 24. What is the proposition there?
82 of 24, Lordship. It is on the endless proceedings, discrepancies in the voters list. Document has to be appreciated and sufficient opportunities were granted. Writ of certiorari. All this is covered in that, and in the other one, Lordship,
Doesn't appear to be ex parte,
it is ex parte, Lordship,
82.
82. Button paragraph ex parte. Yes, yes, Lordship. Okay, to Bahul to like yeah.
This Baharul Islam is on what proposition?
Baharul Islam is covers all the issues and aspects, Lordship. I have a copy with me here. It is. It was an ex parte opinion, Lordship, where this was passed, and I will come to the findings, Lordship. I had placed reliance on Ijjat Ali. Baharul Lordship has got Baharul Islam. Paragraph 14, Lordship. Paragraph 14 is Ijjat Ali, which I had referred to. The case of Ijjat Ali Supra has been cited in support of the contention that a proceeding before the foreigners tribunal cannot be an endless exercise. The relevant part of the aforesaid judgment is extracted herein below. Having regard to the undisputed facts as above, we find that sufficient opportunities had been granted to the petitioner to establish his claim as not being foreigner or to refute the allegation that he had illegally entered into the territory of India after 25/3/1971. In this context, we may observe that although the procedure of identification and for declaring an individual to be a foreign national cannot be relegated to a mechanical exercise, and that a fair and reasonable opportunity must be afforded to a proceedee to establish claim that she is a citizen of India. However, such grant of opportunity cannot be enlarged to an endless exercise. A person who is not diligent and/or is unmindful to take steps to safeguard his interests, he does so at his own risk and peril. In the case of Sarijan Nesa Supra, meaning of sufficient opportunities for a proceeding before a foreigners tribunal have been explained. For ready reference, the relevant part is extracted herein below. Having regard to the facts as above, we find that sufficient opportunities had been granted to the petitioner to establish a claim as not being a foreigner or to refute the allegation that she had illegally entered into the territory of India after 25/3/1971. In this context, we may observe that although the procedure of identification and for declaring an individual to be a foreign national cannot be relegated to a mechanical exercise, and that fair and reasonable opportunity must be afforded to a proceedee to establish claim that she is a citizen of India. However, such grant of opportunity cannot be enlarged to an endless exercise. A person who is not diligent and/or is unmindful to take steps to safeguard his or her interests, she does so at his own risk and peril. In the instant case, several opportunities were granted to the petitioner to establish a claim, which she utterly failed to do so. In this context, we may observe that in the proceeding under the Foreigners Act 1946 and Tribunal Order 1964, the primary issue for determination is whether the proceedee is a foreigner or not. The relevant fact being specially within the knowledge of the proceedee. As such, the burden of proving citizenship absolutely rests upon the proceedee, notwithstanding anything contained in the Indian Evidence Act 1872. This is mandated under Section 9 of the aforesaid Act 1946. The said position would not change even in an ex parte proceeding before the tribunal, as the burden never shifts but continues to be upon the proceedee. In a situation where no evidence is adduced or the burden is not discharged, the only option left to the tribunal would be to declare the proceedee to be a foreigner based on the grounds of reference upon which appropriate proceeding was initiated. where notice was issued and duly served upon the proceeding. In the instant case, the petitioner utterly neglected to participate, contest in the proceedings. Paragraph 16. In the case of Ayub Ali Supra, it has been laid down that the principles of natural justice cannot be put in a straitjacket formula, and in view of the unabated influx, the situation is required to be balanced. It has further been laid down that if a proceedee chooses not to contest a proceeding, he does so at his own peril. In the case of Kadbanu Supra, this court has laid down the requirement of approaching a writ court with clean hands so as to be entitled to the equitable relief. Paragraph 17. In the case of Bhatin Paramanik Supra, the aspect of the provisions of Order 4E of the Foreigners Tribunal, Order 1964, has been dealt with, wherein it has been held that the aforesaid provision of issuing warrant cannot be connected to secure filing of written statement and to contest a case, and if such interpretation is accepted, no proceeding can be ordered to be ex parte. This court has also taken note of Order 3 of the said Order of 1964, which lays down the procedure to apply for vacation of ex parte orders. The rival contentions have been duly considered. The concerned records of the Foreigners Tribunal placed before this court have been carefully perused. Before embarking to adjudicate the issue involved vis-a-vis the submissions and materials on record, we are reminded that a writ court in exercise of jurisdiction under Article 226 of the Constitution of India would confine to its powers to examine the decision-making process only. Further, the present case pertains to a proceeding of a tribunal which has given its finding based on the facts. It is right law that findings of facts are not liable to be interfered with by a writ court under its tertiary jurisdiction. Law is well settled. The Supreme Court, after discussing the previous case laws on the jurisdiction of a writ court for the writ of certiorari, in the recent decision of Central Council for Research in Ayurvedic Sciences and another, has laid down the following. So the certiorari part comes, Lordship. This one judgment covers all the aspects which are there in this matter also. So, and even the powers of the Foreigner Tribunal, Lordship. And another last thing which I would like to rely on is as regards the reliance of new documents made on behalf of the petitioner. This court is of the view that such documents cannot be looked into by a writ court for the first time when it was not filed and proved before the learned tribunal. Though in an exceptional case wherein a party can conclusively establish that he was not at all aware of the case which was proceeding ex parte and certain documents are annexed to the writ petition, the court can come to an ex specie satisfaction on the issue of citizenship of the said party. However, the general proposition would be that when documents were not proved by the petitioner before the learned tribunal in accordance with law, the said documents cannot be looked into by this court, as that would amount to dispensing the requirement of proof of documents. In a proceeding under the Foreigners Act 1946 and Foreigners Tribunal Order 1964, for determination as to whether the proceedee is a foreigner or not, the relevant facts being specially within the knowledge of the proceedee, and therefore the burden of proving citizenship absolutely rests upon the proceedee, notwithstanding anything contained in the Evidence Act, Lordship. This is mandated, then burden of proof comes. And again, Lordship, there are two more paragraphs. May I read it, Lordship? Paragraph 25, as regards to the case of Asruddin Supra and Rajendra Das Supra, cited on behalf of the petitioner, this court had noticed that ex parte orders were set aside in those cases which were based on the facts and circumstances. In the case of Asruddin Supra, there is a specific finding in paragraph 9 that there were sufficient reasons for the petitioner in that case for not being able to appear. As regard the case of Dhaniram Lokar, and the Supreme Court held that Supreme Court laid down the requirement of judicial discipline in respect of precedents. There is absolutely no dispute to the aforesaid proposition, and this court is in humble agreement with such proposition. However, as observed above, the remand orders in the two cases cited were on the facts and circumstances of those cases and cannot act as a precedent. The Honorable Supreme Court in the case of Padma Sundar.
You must just hand over that, we'll return you back this, just,
Lordship, it covers, it was a very long hearing and it covers almost everything.
get copy tomorrow when it returns back.
Lordship. Lordship may keep this, I'll get another printout. All the other judgments which I cited, this court has taken into record all the judgments in Baharul Islam and passed this order, Lordship.
Mr. Amir, anything more?
Lordship, I just
No,
wanted to rely on just one more judgment.
Yes.
That is WPC 5218 of 2018 decided on 7/8/2018 and it's reported in 2018 5 GLT 492. Jonali Das versus Union of India
2019,
2018 5 GLT 492. Jonali Das versus Union of India. Paragraph 4, 5, 6, 9, and 10. I will just read out two lines, Lordship. Ex parte orders can be recalled only on special and exceptional circumstances and not in a routine manner. Rest, Lordship will find it in the paragraphs.
yes, Mr. Amir, yeah, anything more you have to say?
No, Lordship.
But Mr. M. Ahmed, and counsel for the petitioner. Also have Mr. A. Verma, and standing counsel for the FT matters. Mr. G. Sharma, and standing counsel for the NRC. Mr. P. Sharma, and additional senior government advocate. Mr. M. Kalita on behalf of Mr. A.I. Ali, Ms. P. Barwa, standing counsel for the ECI. CGC, who is there? Ms. B. Sharma as CGC. Submissions have been heard, judgment is out.
For hearing, upgraded item 16 with 17.
Yes.
Lordship, in item 16, that appeal filed by the Institute Lordship. And item 17 was filed by the private citizen number 4 Lordship. That is Sunimal Bhattacharjee. That case is led by Mr. K.K. Montosar in that Lordship. Otherwise, my appeal was, if the item 17 is heard, then my appeal also will cover by that. Our appeal Lordship, we are on the only limited prayer that only academic part Lordship, we have challenged that the minimum required qualification for the post of the Lordship executive engineer, whether the bachelor degree and the equivalent degree in engineering acquired by the resolution number 4 was valid or not, Lordship. Only that part, our appeal, because we have on the stand of the certificate submitted by the respondent 4, we have appointed respondent 4. And Lordship, in the meantime,
Where is that certificate? Which page? Where is the advertisement first?
advertisement Lordship at page 47,
47 of which writ petition?
in
Writ appeal?
item number 16, Lordship. My appeal, Lordship.
Okay, page number?
47, Lordship.
What is the date of this advertisement?
25/11/2016.
25/11/2016, Lordship. The date is on at page 48, the below.
Yes.
Lordship, the post at page 47, point number 3, that assistant executive engineer, there are 2 posts we have advertised, Lordship. And the minimal qualification was required. Number 1 is bachelor or equivalent degree in engineering from a recognized university of the institute.
Yes.
And Lordship, pursuant to the selection process, Lordship, we have appointed resolution number 3 and 4 on 1/5/2017. That appointment letter is at page, Lordship, start from 89.
Appointment letter is dated
1/5/2017, Lordship. Page 89 is for resolution number 3, Lordship, and page 91 is for the resolution number 4, Sunimal Bhattacharjee, Lordship. Lordship, before that, I would like to point out that page 60, Lordship, result of the interview for the post of the
Page?
assistant, page 60, 60 and 61, Lordship.
Yes.
Page 60, Lordship. Response number 3 is Bhaskar Chaudhary, and response number 4 is Sunimal Bhattacharya. They were selected as per their merit, Lordship. At the details marks is page 61, Lordship. As per their merit, Lordship, number 3, Bhaskar Chaudhary, he got 75.2. He secured first position. And the rest of 4, Sunimal Bhattacharya, he secured second position, 68. Therefore, we have selected rest number 3, Bhaskar Chaudhary and Sunimal Bhattacharya, and the writ petitioner, he secured, Lordship, 64.5, secured third position.
This page 60, what is the date?
Page 60, Lordship,
4-5.
4-5.
Okay.
Declaration, Lordship. And the results, Lordship,
Result on
4-5. Results, Lordship, 11-4-17. 61, Lordship, 11-4-17.
Yes.
After declaration leisure, Lordship, they have Mr. Writ petitioner challenge the appointment of response 3 and 4. Challenge the degree obtained by response 4. Degree obtained from which Pilani, Lordship.
Please repeat again. We did not follow you. Please repeat again. We did not follow you.
Lordship, writ petition filed thereafter. Instant writ petition.
Yes.
In the writ petition, they have challenged the degree obtained by response number 3 and 4.
Yes.
So now, Lordship, learned single judge in the impugned judgment, Lordship, hold that the degree obtained by response number 4 is invalid as the degree is not as per UGC. Lordship, relevant portion, page 84, page 9, paragraph 15. The impugned judgment start from page 76, Lordship. And the relevant portion is paragraph 15, page 84, Lordship. May I read it, Lordship? As it is
Where is the copy of the degree of respondent before?
Page 260.
260.
Then there will be no merit in this appeal.
Lordship,
Then there would be no merit in this appeal because the degree which you are showing at page 260. First come to page 47. Page 47, what is required is bachelor's or equivalent degree in engineering. And this page 260 is not an engineering degree. It's Bachelor of Science. There is a document showing that Bachelor of Science is equivalent to Bachelor of Engineering.
Lordship, I would like to point out one public notice issued by the UGC Lordship at page 315.
Just a
315.
moment. Just a moment. Yes.
Lordship, the certificate in the head, it is written Bachelor of Science, BS in Engineering Technology, Lordship.
Which page? Which
Page
page?
260, Lordship.
260.
Yes, Lordship. The degree obtained by Rest number 4 is a degree of Bachelor of Science, BS in Engineering Technology.
Correct.
And as per this, Lordship, we have selected.
But how do you say that this is an equivalent to an engineering degree? Engineering technology and engineering as a degree are same and equivalent. So who has said that? Because if page 260 according to you is an engineering degree, then why a degree holder will go to page 261 and then he will have a licentiate examination in civil, why will he take a licentiate examination? Incidentally, in page 260, the date of conferring of this degree is not there. Given, oh, here it is there. On August 2000, 29th day of August, 2009.
Okay.
If somebody has taken a licensure examination 84, goes and takes a Bachelor of Science exam degree on 29th day of August 2000, 2009. It's 260.
Now, Lordship, issue before your Lordship that whether this degree, optimal response of 4, is a valid engineering degree or not, as per our advertisement, that has to be decided, Lordship.
Yes.
Only one issue remains, and response of 3, Lordship, that he already, there is no quarrel
No
about that.
question, no question on the respondent.
Yes, I'm appearing for respondent.
Is it necessary to disturb somebody's argument? If you don't know how to behave, don't stand up.
Lordship,
You want to disturb somebody's argument when we are asking a question?
Your Lordship.
That is how what you have learned in this practice.
Your Lordship, but he mentioned about respondent number 3.
Then you have to jump up.
No, Your Lordship didn't jump up. I was accommodating myself here.
Please
I
don't do it.
apologize. I apologize.
Yes.
Lordship, response of 3 degree is valid as per the Lordship Orissa Leaf Corporation judgment, Lordship. He appeared, he given test and he successfully passed in the examination. Therefore, his degree is valid, Lord. That Lordship, I would like to point out that certificate of response 3 is at page 186. The special examination conducted by the AICTE and UGC and certificate issued in favor of the response 3 Bhaskar Chaudhary, Lordship, page 186.
But this, where is his degree?
Degree is 186, Lordship.
No, this is validation of the degree.
Validation.
Where is the original degree? This is of response number 3.
3, Lordship.
We'll continue at 2. we want in sequence this degree of science, you say is equivalent to engineering. Now, which authority has declared it to be an equivalent? That is the one question. The second, which you are now referring to, is validation of degree, his degree. So that covers respondent number 3 and respondent number 4.
Lordship, the item of 17 that is led by my senior lordship, that too will cover by the vast argument.
That will cover your argument, your submissions also. Mr. Mahanta?
Of the difficulty, and two, of course, let me see. My instructing counsel is not there. That is my difficulty. He is the bereavement.
No,
Therefore-
that's okay, but we have taken up the hearing because the respondent has said that he is out of service.
I
And
told
therefore,
that
we
he-
have upgraded it. So, Mr.
Lordship,
Su-
I
Yes.
have already gone some citation, Lordship.
It's
Lordship,
okay.
just give me one day, Lordship. Then I'll,
Let us see, let us start the matter.
I hope we are back.
Hmm.
Let him place the
You-
facts, my lord,
Ah.
then lots will get the
You,
facts whole.
for the time being, you assist because his counsel is in bereavement.
This is my difficulty.
No,
So
we
what-
understand that.
Tomorrow I can. I'm hopefully, she'll be able to come tomorrow.
Okay, we'll examine.
So my lord, if you lordship
Mr.
permit me,
Mr.
my
Mahanto,
lord,
subject to what you say, we both have been deliberating on your statement. If your assisting counsel is in bereavement, I think it would be appropriate to adjourn it. You say that she'll be able to join you tomorrow.
tomorrow,
take it
hopefully,
up?
hopefully she might come.
Then we take it up day after tomorrow then.
Yes, yes. I'll let it try, my lord. We'll try to do it day after tomorrow.
Yes, yes,
My lord,
because it will be,
Subject to, I hope she'll be there tomorrow.
we live on hope only.
Yes, yes. That's what I'm saying. Because petitioner is
No,
now
we
trying,
understand.
so
we-
let us not, the matter is in the list for long. Now, doesn't risk, therefore, and sometimes in
fine.
research, this difficulty arises. This is difficult.
No, once she is in bereavement, we can't compel you to
Exactly.
make your submissions. We'll take it up day after tomorrow.
Yeah.
If the senior counsel is assisting junior is in bereavement, you obviously can't argue.
My lord, if you allow me, my lord, the both IIT and the respondent appeal language is same, my lord. If Guwahati can be listened, then both will be, because being a private
That's why,
respondent.
that's what Mr. Sudha is also saying. If Mr. Mahanta argues his matter, that will be it will be covering his submissions also. But this is something which we can't apprehend. He is here and he's making a statement that his assisting counsel is in bereavement. Definitely a senior, we cannot expect a senior counsel to argue. Day after tomorrow then.
Obliged.
Just say. Mr. B. Sutradhar.
yes,
The submission of Mr. S. Sutradhar and counsel for the appellant in WA 142 of 2023 remains inconclusive. Next paragraph. Mr. K. K. Mahanta and his senior counsel, who's been instructed to appear in WA 350 of 2022, has submitted that his instructing counsel is in bereavement and she is likely to join only on first, on 3/04/2025. Taking in view of the bereavement of the instructing counsel for the instructing counsel in WA 350 of 2022. The court is inclined to adjourn the matter today. Next paragraph. Mr. What was your name?
Dipankar Das, sir,
Mr.
respondent.
Dipankar
Dipankar Das.
Das. The respondent number 4 is present in person and he expresses some urgency in the matter. So stop, Mr. P. Chaudhary, Learned Counsel, appears for respondent number 3 and
Thus, for respondent number 1 on behalf of SK Bakery,
M. Das, Miss M. Das, Learned Counsel, appearing on behalf of Mr. S.K. Belik, CGC for respondent number 1. Name. Item number 16 in WA 142 of 2023. And you are for 350. Okay. WA 350 of 2021. Miss Das will be for her.
R. Bhuya on behalf of Mr. A. Soma for the UTC.
R. Sharma.
Bhuya,
On behalf of
Mr. A. Soma.
A. Samwa, Council for respondent number
Respondent number 4, Lordship.
4.
Yes.
UGC.
Yes.
For the UGCs are present. Next further. List on 1/5/2025 as part of matter. Item 5.
Yeah, Lordship, as per the opinion, Lordship, the petitioner's father has not been cast in post since last 1970, Lordship, and that part is reflecting, Lordship, page 75, Lordship. The opinion part of last page, Lordship.
You see, earlier when we issued notice, it escaped our notice.
Yes.
Why have you made Mr. Sharma as respondent number 4? What has he done? What Mr. Sharma has done? What is your grievance against Mr. Sharma? Why you have implicated Mr. Sharma as a respondent?
That's number 4.
Mr. Das, we'll request the bar to show some mercy on us. We will pass orders, then we'll check the cost title, then we'll find out you have made Mr. Sharma as a party and then pass orders. You have absolutely no regard to your own duties as a council.
Lordship, this is
We'll
for
dismiss
cost
the writ
title.
petition, you file a new one. Why you will make Mr. Sharma a party here?
Lordship, I'm sorry for that, Lordship.
No, it's not a question of sorry. After drafting, look into it. Why Mr. Sharma would be a respondent? Tell me one good reason why it should not be dismissed. Why should we take all the trouble of reading the petition, reading the cost title, reading the affidavit, reading the name of the parties and come prepared?
Lordship, the title, amendment title already submitted, Lordship.
Respondent number 4 is special counsel for NRC. Why special counsel for NRC is a party?
Lordship, I may allow. to-
No, you will dismiss it, you file a fresh one. Will not permit it. I'll not waste my time reading the brief only to find out cost title.
So, Lordship, the.
I go from here from 6:30, 7 o'clock. After this, a bundle of cases come and then we read. And then this is what we find out. This is not the way you'll move the matters.
So here the special
For
counsel.
non-general, we dismiss it, we allow you to file it afresh. We'll give you liberty.
Lordship, is a-
We'll dismiss it. No, we'll not tolerate. I will not, once now I file, from now onwards, when I file a defect in the cost title, matters would be dismissed. You file a fresh one. No question of rectification.
When you give the one chance, opportunity.
We are giving you a chance. We are giving you an opportunity of coming afresh.
The response number 7 has a amendment title lordship. So the.
Now,
six-
every time, that's why we say, every time we look in the cost title and then make, allow you to do corrections. This is not the manner in which we will proceed. Don't I have a personal life? Can't I read anything else in my spare time?
So lordship,
No, please tell me, tell me the profile of my job. What do I have to do? Tell me, guide me.
lordship, the NRC documents I made the party lordship, the documents is available lordship. Page number 20.
Heard Mr. R.C. Das, learned counsel for the petitioner. Also heard Mr. G. Sharma, learned standing counsel for the FT matters and NRC. Mr. P. Sharma, learned additional senior government advocate for the state. And you are also there? No. Next para. We noticed from the cost title that the party raised as respondent number 2 is the special counsel for NRC government of Assam. So there is no averment in this writ petition that there is any cause of action against the learned standing counsel for the NRC appearing before the court. Full stop. Accordingly, due to lack of any averment against the respondent number 4 and in absence of any prayer against any action on part of the respondent number 4, we deem it appropriate to dismiss this writ petition for owing to defect in the cost title and the presentation of this writ petition. Next para. However, taking note of the fact that the petitioner is agitating her citizenship right, which is considered to be a valuable right, we grant liberty to the petitioner to approach this court again. Next para on. No, that's all. The case records, which are the tribunal's records, which have been called for and received, shall be retained for a period of retained by the registry for a period of 1 month from the date of this order. Please have mercy on us. We can't go on reading like this. We'll first pass orders, check it, sign it and go home. Then we read the files and then this comes up. What Mr. Sharma has done.
I'm sorry for that. Masabat.
Item 6.
May I please your lordship?
You have called for the records. It was an ex parte opinion.
Lordship. Lordship,
Yes.
Lordship, earlier FT case has been registered against the petitioner. Learned member has declared Indian. Lordship,
Please, have you examined Mr. Sharma? You have examined the records? Just go through it. There's a previous opinion declaring her to be him to be an Indian citizen. Just check up. 2 records have been called for. We'll take it up after some time.
Lordship.
7 with 8.
My lords, the other day, the opposite parties produced some pictures and photos.
Yes, wait.
And we were expecting
go.
that copy should be furnished to us, but that is not yet furnished.
No, we understand. We'll have to go through it. We'll furnish you if, let us be satisfied first. Because you have a definite right. We understand that. Just wait for some time. Mr. Das in raise, Mr. Nath in raise, after some time. It's okay. Just wait for some time. No, don't have it. Just wait for some time. He's coming. To the other members of the bar, after this matter, we may not have time to take up any other matter. Because at 3 o'clock, we'll be rising for another division bench. This bench will break at 3 o'clock. Mr. Mahmood matter, will take it up. Other matters will be adjourned. Mr. Kaushik, you are there for some criminal matter?
Sir, I'm waiting for the another division bench.
Okay, for the
And
division
that-
bench. Okay.
Here I have a matter on behalf of my lord Dimahasa Autonomous Council.
Yes, I understand. Okay. Just wait. We'll rise at 3 o'clock.
Lordship, item number 18, Lordship, this matter relates to non-payment of pension. It is regularly releasing, Lordship, but not.
We understand.
Lordship.
What is the office note here?
Office-
Please just come up with an office note. What is the office note?
I have not gone through it, Lordship.
Just check it up.
Lordship.
My lord, item number 14, my lord. It was listed last week, my lord, and
Those will be
Yeah, it-
taken care of by the court master because we can't really
only a
fit
date,
this
my
in.
lord. a date.
We are not giving a date right now.
All right.
All this will be rolled over.
All right.
And this, Miss Devi. Oh, what are these matters? Item 18 onwards to, what is this batch relating to?
Lordship, by the common judgment, Lordship, and the learned single judge has rejected the claim of the petitioners to all pensions, Lordship, under service rule 90, pension rules 1969, and stated that they are entitled to no new pension after their retirement. My appellants here, Lordship, they were retired.
But the documents show that they were appointed after the new pension scheme was announced.
No, Lordship. In my case, Lordship, these are the Dimahasa case, Lordship. There are 6 scheduled areas. Their case is something different from the others, Lordship. Because they were appointed during 1989-90.
But that was not a regular appointment.
Under the autonomous council lordship,
But those were not regular appointment.
under the autonomous council, as per their affidavit lordship, it was created by the autonomous council, non-government sanction post created by the autonomous council lordship. And they have.
But if it is non-government sanctioned post,
Lordship.
then who
But-
takes the responsibility?
But after that, lordship, during 2007 to 2013, they were regularized.
Because that's what the question was. You see, if the persons are working in non-government sanctioned posts,
Government
those posts are created by the Dima Hausa Autonomous Council,
lordship.
correct? Now, who pays pension?
Lordship, during 2007 to 2013 lordship, they were regularized against government post lordship, government sanction.
State
post.
government post.
State government.
But that
post.
was post new pension scheme. We
But
don't,
lordship, Lanet Singhal just held that these are not regulation because they were bought under the fault of the state government lordship. Otherwise, they were regular appointees. Therefore, there was no question arise to regularize them after new pension scheme came into effect. The Lanet Singhal just only held that since these posts were not
Okay.
pensionable under council area lordship, therefore they are not entitled to regularize.
just check up why those, what is the office note? Just check up. We'll see. Yes, Mr. Nath. Mr. Mahmood, please come forward.
Here, in this case, person to lordship's last order, the second last order, right? We have produced the copy of the photograph. And on last occasion, referring to the photograph I submitted, that in fact the reports are also there, copy lordship is on record, copy of the photograph.
No, we had put some queries on those photographs. Did you have some clarity in the matter?
So I have asked them. And
Because unless you get the assistance of a expert, forensic expert or someone who's acquainted with this the death of hanging. Because this prima facie shows that it it may not be a case of, because you don't find that adequate space is there where the person can go and hang himself.
But
But there's also one issue. Last time we did not consider it, but I think in these cases, when we are relying on this photograph, we have to give a copy to Mr. Mahmood so that he can at least respond to this. Otherwise, he'll be in a disadvantage.
But I have the checkup and the ultimately whether this is the case of hanging or it's a murder, and after murder he was hanged. The medical reports, the postmortem report, and other things that has to be taken note of. That those are very important. So in this case, those reports are before your lordship. All these
Videography report is also there. Videography of the postmortem is available.
videography of the
Because the situation which was prevalent at the time of the postmortem.
Hey, can you show me? You pull it was. Videography done. Videography shows a file doesn't a photo from them here. এখন আমি তাদের জিনিস সব ফটোটা আছে তাদের ফটোটা পেকার দিয়েছে পেটিশনার দিয়ে City এনেকে চাই আছে। Lot. Inquest report.
Microphone. Microphone काम करा।
Dot. City level. No, those are some special person's capability has no. We have seen, but true. 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 But we have to go by the general thing, Milord. Milord, in the affidavit filed by the that's true. Lordship has indicated the I do agree with that, Milord, because the possibility has to be there. Although Milord, I am arguing that no other injuries are there. Ultimately, the possibility definitely has to be there. But only page number 120 is the part of the affidavit of the SP, because after the Lordship's order, we have filed this affidavit. there, my lord, we have given a description of the place. My lord, I do agree, my lord. Some photograph of that thing, my lord, and the location, the what is the height of the ventilator and all these things, that will give some indication, my lord. আচ্ছা। না, না, আমার মাথায় কথা হচ্ছে, আপনি নাকি তো মানে ওর চিঠিখানা আমার মাথায় লেগে আছে। এই মাত্র মনন বলে। মনন এই ইউনিভার্সিটি এখন আছে, এই চিঠিখানা ধরে 3 মাস চলতে আছে। আপনি কোশ্চেন করুন। ঠিক আছে। ভেঙে পড়ে যাবে। হ্যাঙ্গিং ফটোগ্রাফ তো
Is that gamusa by which the person was hanging was seized? Is it available? Can you just?
the দুটা রেকর্ড থাকিব লাগে না কিবা এটা ৰেকৰ্ড থাকিব লাগে
You want the record?
some
Please.
some record no matlab some case diary copy of the case diary maybe in the record.
Oh, it's there. It's available.
Yes, yes.
It's available.
So in the case diary possibly the seizure is there.
Seizure is there. Okay.
Seizure is there. Case diary also. My
Lord, I have one. I have two submissions. First submission is this, my lord. So far, the defense point they have taken, in my humble opinion, those are only to get rid of legal consequences. But this poor lady, who is the mother, her condition is bad. She lastly instructed me that for the time being, there are two cases. One is 7, another is 7 and 8. 7 is for compensation. We have paid 20 lakhs for killing my son and brother. And 8 is for high-level inquiry. So high-level inquiry that may be done by the district judge Barpeta, if your lordship so desire. That is item number 8. In 7, my lord, if your lordship's prima facie satisfied that these are the lame excuses only to get a legal consequences, and after all, Supreme Court is very much clear. The person may commit suicide or otherwise died, but it is the responsibility of the state. It is very much, so many judgments I have, and I have also brought today some judgments. They cannot evade their responsibility at any cost. Even if suicide, even they are liable to pay compensation, because the same incident happened inside their custody. When he was in jail custody, in their custody. So if in item 7, my learned friend agrees or lordship desires, then some compensation may be provided and case will be disposed of. In that view.
No, for that you'll have to make a prayer. Number one, to not assign any liability to any person, and then hold the state responsibility to make a payment. Then the matter ends there. But if you have to record that there is something which amounts to custodial torture and death, which is otherwise homicidal, and that therefore it's amounts to murder, then we'll have to record a specific finding.
But that 8 is there. I am not on 8. I am on 7.
That is only an inquiry.
Yes.
That's
That will be
only
done by London District Judge Barpeta.
No, but what finding do you want us to record in the first case when we are granting compensation?
Prima facie, lordship, I think your lordships are satisfied. There's some.
No, we are just discussing. It's not a formation of opinion. It's not a formation of opinion. But what do you want us to record when we are awarding compensation? Because we can't pass two contradictory orders. Number one, we say that there is nothing against them. State will pay compensation because it was a custodial death. That's one part. Having said so, in the second case, we can't issue a mandamus making a high-level inquiry because we have recorded a finding. The problem is there. We have examined all the pros and cons to limited understanding. We may be wrong, we don't know, but we'll have to record some finding in the while granting a compensation. What would be our finding? Just tell us. according to you?
I recollect only prima facie, I am saying, I am not
No, but prima facie what?
desiring to get the final
No,
opinion.
no, I understand, but prima facie will say what?
It appears that the person, the Hasibul Islam, who is a young boy, 20 years, was killed, either killed or committed suicide.
No.
In certain sense, the
In
government
a-
cannot
in a writ petition, we
escape
can't
from
say
the-
either this or that. We have to give a definite finding.
No, that is true, my lord. That was he committed. They say
Once we
committed suicide.
once we pen down any order which exonerates criminal liability, it was be very difficult for us to take a U-turn in the second case and then say, please issue a. That's why we are hearing this matter.
Mother is.
No, we may be wrong. We don't know. We are
No,
not saying
my
that
lord,
we
I
are
am not
right.
wrong or right. My only
It's just-
prayer is this: mother is
Because there
like
must be
that.
some,
So
we must record some finding somewhere. What would be that finding? Now let us say we take it that since it was a custodial, pay compensation. But then supposing Mr.
responsibility
Nath,
to be fixed.
supposing Mr. Nath now wants to assail this order, it will only say that the High Court without any finding has settled the state with the liability.
Finding the
Because
referendum.
because you see,
Judicial inquiry, commissioner's inquiry, their affidavit. And these are the matters which may be taken into note at
And
the
those-
time of finding. If that is what was instructed by my client.
no, we understand that. We are not questioning that. But we are trying to find out an answer as to what would we record. Once we make record a statement here, if for some reason it is it runs contrary to the prayer made in the second writ petition, then you will be in trouble. That's why we don't want to. We're trying to get out because what has happened. The reason is number one, there are two inquiry, one by a ADC, and the second is by the judicial magistrate. Now that judicial magistrate inquiry is covered by the CRPC, and there the finding is suicidal.
We do not believe the ADC's
No,
inquiry.
you do not.
Or
But
believe
then we'll have to
judicial
receive.
inquiry.
But that is the second prayer. We'll have to discard that and send it for a fresh inquiry. But then you see that there lies the problem. Because while passing compensation, we say something, we don't fasten the liability, and then say that we doubt the report in the second case. We have examined that. That's why on the last two occasions when we were hearing it, we told you that.
My client is instructed like this. That's why my position is not good.
Just one.
Logic.
Mr. Nath,
My lord.
taking what Mr. Mahmood is saying at his face value, because still we can always grant a compensation. So 2 lakh rupees as interim compensation can still be granted pending hearing of this matter.
My lord,
Because otherwise also custodial death, you'll have to pay as per your own notification.
that will be on the principle of strict liability.
Yes,
Strict liability.
strict
My
liability.
lord, here, my lord, the two petitions, one has been filed by the mother, other has been filed by the brother. And prayer, lordship may kindly consider the prayer made in the both the petitions, my lord, involving same incident and the same, my lord, the incident, my lord. They have, my lord, in one case they prayed. In fact, in the petition filed by the brother, WP Criminal 1 of 22, they have prayed, my lord, page number 17.
Yes.
The calling upon the respondents to show cause as to why the investigation of Borpeta PS case number 2222 of 2021 under section 420B and so IPC, it should be possibly 120B. IPC shall not be directed to hand over to CBI to make the investigation fair and free, fair, uninfluenced and acceptable considering the facts and circumstances of the case, and bring all the criminals involved in the murder, alleged suicide suicide case of Hizbul Islam, the younger brother of the petitioner, into a logical and to show cause as to why the action of the police personnel connected with the crime and investigation of the case shall not be declared a colorable tardy and unfair investigation and to show cause as to why police.
Mr. Nath, I understand what is coming from you. You will, what you call, very simply say that once there's a finding of the judicial finding, then unless that is challenged, possibly there will be two arguments from you. Number one, unless that is set aside, the question of unfair investigation or not fair investigation will never arise. Correct. That is one part.
That is one part.
Second is that the process when the FR is filed is that Naraji petition has to be filed and therefore it should be proceeded with. That's one part. It's the second part. But but we think that when it is a case of custodial death, those few considerations can be overlooked by this court because it's got nothing to do with that. Judicial inquiry being ordered would be normally to the district judge, subject to what you say.
Malad.
And therefore, the procedural aspect is something which we would have power to more relief.
Lordship, that's true. That's true. Lord, here the ultimately the grievance of the petitioner is that the person, we said that it is a suicide. They said it is not suicide. That is his basic grievance. And the grievance is that the whatever investigation we have done and whatever report we have submitted, those are not believable. And Lordship is examining that whether the person committed suicide or whether he was killed and he was ultimately found hanged. So that, my lord, is already, Lordship has already examined the record.
We're trying to look into it. Examination is something which we are not equipped.
Lordship.
There has to be a factual inquiry.
The records, my lord, whatever available before.
Whatever is available record, when we prima facie see it, what do we find? That's the first thing, because you see, even the recent cases by the Supreme Court last month, it has laid down parameters of when inquiry by the CBI or external agencies can be made, because we'll have to record a finding that the investigation carried out so far does not inspire our confidence, and therefore an outside agency will look into it.
That's true.
So it is only to record our prima facie satisfaction that we are examining these matters.
Malad, in fact, I would humbly submit, Malad, that ultimately a death has occurred. That is the final thing. Malad, if Lordship is satisfied that yes, he has committed suicide, because all the reports and the circumstances which are before your Lordship, it Malad indicates that it is a suicide. Then Malad, ultimately the question comes that even if it is a suicide, it is within our custody, then strict liability. So whatever my learned senior has now, he has expressed. So that would be the final outcome. And Lordship is hearing the matter, Malad. So in spite of directing interim.
That is where we both have deliberated. And prima facie we find that if in one matter we say that strict liability is there, then the issue of this prayer because then you see we can't appropriate and reprobate the same breath.
True.
Once we say that it's a question of strict liability, that means there is an exoneration to the state with regard to the specific liability.
Malad, I'm making my submissions for that only. Malad.
We understand that.
Lordship.
That's why I said before you begin.
Malad, this is a case, Malad, where the records and the reports, it suggests that it is a case of suicide.
No, that's
It's a case.
we are neither saying anything in favor of Mr. Mahmood right now, neither we are saying anything against the state right now.
Lordship.
We're just trying to examine.
Lordship. So
And we're trying to have the what you call a mental creation of a scene of the accident.
Lordship.
Now here is something which is very lacking. There are two reports. The two reports do not give the size. It does not give the height of the ventilator from which the suicide was made. Then we only have one document which says that on the day of inspection, the magistrate found that that in the toilet, the ventilator was there, which has now been shuttered with a tin. And therefore, it is only after this shuttered tin are removed, then we come to know the exact height in which the body was found hanging. I told you that some report says that the inquest report says height of the person is 153 centimeter. That's why we, when we try to discuss and we try to recreate this scene mentally, then the last time we saw the photograph and the distance between two walls and the possibility of somebody going up and then committing a suicide. We were just trying to visualize that.
Logic.
Correct. And then because of the height, we are trying to mentally measure what would be the distance of the left wall and the right wall from the position of hanging. What would the mean distance between the two? And therefore, the second possibility which we were examining on that day was that if you see there's a what do you call, let us say this is the ventilator, this is the rod. Now, for somebody to precisely come in between to hang, some 60-40 is there in the place of hanging. That means a person who is hanging, who is trying to climb a wall, is balancing himself. He's also maintaining the mean distance between the rod for the purpose of hanging. Because is after the weight is put on the gamcha, the gamusa is taking the weight. For the gamusa to slide from place A to place B, because you see, this is the wall.
Sliding cannot be because
This is the wall. So
Logic.
somebody will be standing on the wall. The best way to hang is from the nearest part of the wall. So to lean forward, go to the middle and then hang himself. This is what creates a fundamental doubt.
in fact, the
Please understand, we both are not experts.
logic.
We are just trying to visualize whether that is in any way permissible, possible.
Possible.
So only because of that, because we have to formulate why we should send the matter for examination.
Examination
Therefore,
or lordship will record satisfaction that yes, it is. That's
so therefore, what we were thinking before we sat in the bench is that whether we can have the either the superintendent of jail or say secretary DLSA to examine that bathroom with attached to room number 3 and tell us the dimensions and the height of that what do you call
The
rod
ventilator.
from which is hanging.
ventilator.
So
Because
that gives us the description of the room.
logic.
Because till now we don't have, you see, two magistrates have done the inquiry. They have not calculated the height of the wall. They say it's a half wall. So what is the size of the wall? What is the distance between the wall and the ventilator? These things are not available. Therefore, it's very difficult to visualize what has actually happened, whether it was a suicide or it's a custodial hanging.
But that if the secretary DLSA does it, it will be good.
Secretary DSO or
But I have
superintendent
objection.
superintendent
I do not believe superintendent of district
No,
jail
that is why I have.
or that is, we believe only district judge.
No, but district judge won't make that inquiry. That would be
Because they have heightened the wall after this, as I have been
no,
reported.
no. That's not available anywhere. Only what they say is
No, in our case, we have made it is, it was at the time of the so-called suicide, it was nearly 3 feet only. And if a person sits for this, for urinating or any other thing, then his head is visible. So how?
where is that statement made?
Yes, my lord.
This is
that is-
something which we have missed.
Yeah.
Below the ventilator, there is a window. Window has some horizontal rods.
Right.
Photograph indicates the horizontal rods also
My lord, may
somebody
kindly
can
see
take the
page
help of
9
that.
and 10
Which writ petition?
of 6, WBC number 6, page 9 and 10. Kindly see page 9 bottom. In this regard, page 9 bottom, In this regard, it is ought to mention that though police has given the death of Hasibul Islam a color of suicide, but after his death, the petitioners that police. So he filed application. Skilled and hanging with a ventilation of a small latrines inside the jail. It is not possible that a person who committed suicide would cause injury in his person before committing suicide, and that too in presence of so many security guards of the jail. Moreover, the latrine is very small and same is bounded in such a manner that if a person sits in that Indian-made toilet, which is installed in the jail, half of the upper part of the person remains clearly visible from outside. So, if a person sits there for urinate or
You have that photograph? Where is that?
I have given a photograph.
Where have you kept it? This is a photograph. Last time this is a photograph.
Last set of this ছিল but আমাদের এখন দিলে আমার নাই রে আমাদের আর নাই
We show it to that photograph.
I've given.
Yeah, give it.
Yes,
You have seen that?
yes,
You see the first photograph where the person is in a hanging position. This is a photograph taken on 12/10. On that day, this is the height of the wall. So it can't be your case that while the person was hanging, the jail authorities, they raised wall. And the wall, the third photograph, second and third photograph shows people. A man would be about 5 feet. We won't say 5'2" or 3 or 4. At least he would be 5 feet. So wall is higher than 5 feet at least.
we have also made that thing
No, that-
clear in our petition. However, all these informations of suicide have been collected from police as neither the petitioner nor any of the near relatives were allowed to visit the spot.
Mr. Mahmood, we are not saying your statement is false. What we are trying to say, when we gave a suggestion that we need the description of the house, you say that it has been altered. So if there is an alteration, it is evident on a photograph which was taken on 12/10 because on that day, this person who was said to have hanged himself, victim, was at 1:15 p.m. And after this, crash message has been sent to the Human Rights Commission, to the police authorities, to the district magistrate, and then on next day the what you call the ADC came and gave its report. There gap of 2 or 3 days. ADC and the judicial magistrate. So till that day, at least there was no alteration in the size of the wall. It's not there. But the judicial magistrate writes in the order that when she visited, he or she, I forgot, he or she visited the jail and the room, the ventilator was shuttered with a tin. So that's the only change which was made. Apart from that, the 3 feet wall, we are not finding it here.
That was on the CCTV camera was on that day there is no
That's okay.
CCTV camera.
That's why we are examining.
So however, my lord, if possible, my lord, in the interest of justice, some interim compensation may be awarded pending final hearing of the matter. That there is no bar, my lord, and there is so
Without
many.
giving any recording, interim compensation of 2 lakh rupees at this stage. It's a 22 matter. We are now in 25.
Malad, that is what Malad I submitted, Malad. That if it is not a case of Malad murder,
Then we can, once we are giving interim, that would be subject to final outcome, whatever we say. Otherwise, also statutory liability will always be there. To give some support to the petitioner. Mother will at least get something.
Lordship, here is a case Malad, where the Lordship has Malad indicated that the Secretary DLSA will go.
We'll
Malad,
take it up
I-
day after tomorrow,
Malad,
because for the second bench.
1 minute,
Uncle
Malad,
Judge-
I am submitting 1 point. In a
We'll take up day
layman-
after tomorrow.
only one sentence.
No,
my lord.
my honorable sister has come for the second bench. We can't possibly keep her detained. We are not saying anything. The court will take care of it. Day after tomorrow. Both sides are represented. The both sides are represented. The prosecutor matter could not be be heard. List again. The hearing could matter could not be heard. List again on. It will be 1st May. 20.
In item 5, Lordship, there was an interim order, Lordship, that may be vacated, Lordship.
Division bench item 1 with 2 for hearing.
Both of you have seen the records. The, in the 313 statement, we have got the,
Address of the
address.
requited person, Lordship.
So are we required to issue notice on them?
Lordship. The registry was directed, Lordship.
But the notice which was sent appears to be sent in a correct address then. You see, we'll send you the records. There's one, Mr. Kaushik, there's one blue flag.
Yes.
In the top. After that, there's a pink flag. Before that pink flag is the office note. Then down below, there's a flag, yellow flag, which is called scan copy. Because then, if they are absconding, then the police, after their report, will have to declare them, will have to suggest to the court that they are absconders. And thereafter, we will have to direct the sessions court to take up the proceed, declare them as an absconder and send the records back.
My lord is talking about this pink flag.
Yes, just before the pink flag, there is another
Blue flag.
document, office note. Yes,
Yes, madam, that I have gone through, my lord.
we have gone through that.
Yes, sir.
Then there's the yellow flag down below. It's called scan copy. Yes, right side. Yes. This is the 313 statement. Added is same.
Yes, sir.
Last line of the printer form, I resided, so Pathar.
Uh.
So that means the process was sent to the correct address.
Correct address.
So the concerned magistrate will have to, the police will have to give a report of the person not being found, and thereafter only the process of declaring an abscond can be made. Or is there any other procedure?
My knowledge, that is the procedure, madam, but I'll have to check and otherwise. Dada. Lordship may kindly peruse order dated 18/3 of 24. Madam,
Order dated
18/3/24, madam. Lordship got it.
yes.
Para 6. Last portion, upon whom notices were issued and those served have not appeared. That means those address are there. Because the word is here, those served, madam. But they have not appeared. So address is same, madam.
No, because you see, once we have issued a direction for registration of a
Yes,
suo moto revision,
That's right. Then again,
then we'll have to serve notice.
again, madam.
Who was earlier appearing? You were appearing for them. No,
No, Lord.
but somebody was appearing for them. You were appearing.
He's appearing for the acquitted persons
Huh.
in the.
No, for those accused, he was appearing. That's why.
Mm.
You got instructions? No. Have you received instructions? No.
But he were appearing, na? Hearing separate case number, were acquitted, separate case number 131.
Not in this case, madam. Not in 347. Not in 347.
Please tell us, let us say we issue a fresh, in terms of the 313 statement, the address are same. We issue a notice to the, to those persons, 6 persons. And after that, let us say the notice is not served. Under the Guwahati High Court rules, the power to declare an absconder by the High Court is not available.
Not available.
So it has to go back to the magistrate to have the declaration, or to the sessions. Who will do the declaration of absconder? Will it be the jurisdictional CJM, or it will be the jurisdictional sessions court?
Here,
Hmm?
session case. Session tribal case, not session tribal.
Sessions tribal, so therefore it will be sessions court will do it.
Lordship, the appearance stage is at the magisterial court, Lordship. The appearance stage, and thereafter it is committed to the session. So that is.
Yes.
We are now only registering a suo motu revision. And it is in that revision we'll have to say what to do. The jurisdiction of the fresh trial is not even vested to them.
This appearance is limited to my understanding regarding this revision only.
This revision for which we'll have to record their presence and then pass orders that they will be tried afresh. So it is for that purpose only. Subject to what you say, because that's what we think.
Right.
If we are incorrect in our thinking, please tell us.
Actually, this is the first time I'm facing this kind of situation.
No, that's why you see, because that's why this revision was suo motu, because we can't
Yes.
pass that order in an appeal.
Yes, right.
Because there was no appeal against the persons acquitted. In this, we found that there was impropriety in the passing of the order, and therefore the acquittal was interfered, was questioned. And then we registered this suo motu so that that can be the earlier illegality in the order can be rectified
Right.
in a revision, because there was no appeal
Yes.
against acquittal by the state. Because ideally, we could have made the things easy by directing you to file an appeal, but that we did not deem it appropriate to pass an order directing the state to file an appeal. The state may not want to file an appeal
Yes.
in a given case. So the problem is because we found some fault with that order recording an acquittal. That's right.
Madam, or my lord,
Sorry.
10, 11, 22.
We'll examine the records and pass orders in the chambers.
My lord,
For the, so directing the service to be made afresh.
I think, my lord, I'd like to point out, because here, if the court wants to declare them absconded, the court below, my lord. In that case, the whole procedure has to be followed, because in case of section 82.
No, that will happen. It's a second, that will be the second part.
Second
First
part.
part is that we have to record satisfaction about the due service.
Due service.
And if there is, if it cannot be served, then we'll have to pass an order directing the trial court, the concerned court, that if the service cannot be made, they will examine the process server or the police who's gone to service, and then record its satisfaction that the persons are absconding. And on culmination of that process, they will return the records back to this court. That is not, that is what we think the procedure should be. But please tell us if we are wrong. Because this court, under the High Court rules, we did not find any power to declare somebody as an absconder.
Yes.
So therefore, we thought that this only alternative would be to direct the trial court. Oh, sorry, not the trial court, the concerned court who is in charge of the process to serve it. And if it is not in accordance with law, or sorry, if he's absconding, then the court will record that and send it back, because that is the second proceeding. There has to be a second proceeding for the purpose of declaring an absconder.
Yes, sir. Warrant has to be issued. my lord.
Yes, warrant has to be issued. And thereafter, on that, so it will take some time to
Time.
complete that process.
Yes.
So we are in cognizance of that, and just will pass orders in whichever. Let us discuss and pass orders. So this is a situation I personally have not come across. And as a court of record, we don't want to make mistakes.
Understood.
But please tell me if we are to do something. Just tell us so that we can be well guided.
So, my lord, at this stage, I am also thinking like that, only if something comes, I will.
I think the lordship is correct, lordship, in the procedure.
Correct, I won't say, but we think that to be the appropriate way. Correct or not, that only time will tell. Copy करूँ, बारे में भेज दो। Copy करूँ, पूछे दो। For the time you do that, record photo give back. हाँ, जाने के लिए पता नहीं। अब ऑडियो कॉपी आई है। तीनटा कनेक्टिंग बाय डिवाइस मैं एक सब लगा दीजिए हम शरीर में लगा अब नाम रिकॉर्ड बिजनेस रिकॉर्ड You get your names recorded. Mr. Kaushik,
Madam.
and you also, Mr. Chaudhary, I forgot your name, I just, Mr. Bora. You see, I'll just recapitulate. There were 9 acquittals. 5 of them he appears. And he has stated that he has no objection to send the matter back. Insofar as the process is concerned, is with regard to only 4 people,
Lordship,
correct?
Lordship.
And those
Four acquitted
four
persons.
accused persons are Abu Bakr Siddiq, Mubarak Ali, Tajuddin, and Bayat Ali,
Yes, madam.
correct?
Lordship.
This is the 4 persons. Correct?
Yes, madam.
The paper book, page 164, Lordship.
No, it's okay.
Lordship,
I'm
yes,
just recapitulating,
correct,
that's the correct position.
In item number 2, Lordship, we have filed one interlocutory application for one of the accused appellant, Tajuddin Bhuiya. Insofar as this present case is concerned, except for this appellant and another appellant, all the other appellants have been enlarged on bail. And my respectful submission is that since a coordinate bench of this honorable court has already taken a decision, the matter in all likelihood is to be remanded back. So I pray that this petitioner, because during the trial stage, he was all in on bail. So my respectful submission is that he should be enlarged on bail at this stage. He has completed
is-
more than
which-
8 years in
This is
jail.
the IA, 463,
463.
Tajuddin Bhuiya.
Yes.
Yes,
But he is among the 4%, madam.
I have annexed all the orders by which this honorable court has granted bail.
Tajuddin and Tajuddin Bhuiya are same person.
Tajuddin Bhuiya again.
No, Tajuddin Bhuiya is one of the appellant, and from their side also there is another person by the name of Tajuddin,
That's not.
They're 2% by the same name.
but 2% by the same name. And since during the trial, he was all along, he was on bail. And last 2 years, he has been waiting for, but the case is not proceeded, Lordship. Only on that small point.
Okay. Yes,
But
he was arrested when? Please tell us.
He has been serving jail sentence since the date of judgment.
Date of the judgment. What is the date of
Yes.
judgment?
Date of judgment is 16/2/2018.
16 to 2018.
Yes. And I have
Today it will be about 7 years.
Yes. And I have annexed all the bail orders by which the other accused appellants have been enlarged on bail, starting from annexure 1 to annexure 4.
Okay. And in the criminal appeal, what was the finding against this person? What?
Allegation as far as the witnesses are concerned, there is a common implication that all the accused persons, some of the witnesses have submitted, mainly which has emerged from PW 6, 7 and PW 10. That these are the person, all the person in fact, they assaulted, and primary allegation is against one Sirajul Bhuiya. He is also enlarged on bail. Oh. No, objection file for me.
Life থাকে তো আমি করবো না mandatory.
কিন্তু 2 বছর আগে বাকি আছে। কিন্তু ultimately suppose this legal procedure এটাই হতো না।
Mr. Ganguly,
Lordship.
because the sentence against you is also for life,
Yes.
and therefore if the matter is pending only for the appearance of these 4 persons, except those 4 persons will split up the matter then. Pending their service and appearance. And then we can hear the appeal. You see, the difficulty is,
Whether my receivable submission is.
the
whether
difficulty is that, you see, we took a view that it should be heard together.
Yes.
The persons who have been acquitted, we took a view that that without hearing the cross case, the acquittal could not have been granted.
Yes. In fact, there ought to have been 2 judgments.
There ought to have been 2 judgments. And therefore, it is in that context that we wanted this matter to be for them to be served notice and brought back. But if you have, because if you are pressing for that bail, we can also exercise jurisdiction to split up the matter and then hear the matter. Because then once we split up, then even in the absence of those persons, we can still hear the appeal once it is split up. Because when they join, we can again proceed with the matter and then hear it.
Also, the problem was there was one judgment.
One judgment.
So if we hear the appeal and later on if Lordship decide to set aside the judgment, their acquittal will also be hindered.
Yes.
That is why they were called to be part of it.
Because
Because in
that
one
court-
judgment, some people have been convicted, and because there are 2 cases. The other case, all the people were acquitted. If that judgment is set aside, that was the view the Lordship had given.
Yeah, because
That is why we are waiting.
that order, if Lordship comes to that order, 15/6/2023 order, at para 39 of that order, as stated earlier, a perusal of the paper book at the record clearly shows that no separate evidence of the common witnesses had been recorded in respect of a particular case by the learned trial court. There are many prosecution witnesses in both the session cases. However, there are also a few common witnesses in both the case for which separate evidence was to have been recorded for each particular case. The same not having been done, the matter would have to be remanded back to the learned trial court to do the needful. Further, as per the law laid down by the apex court, the learned trial court will have to dispose of the 2 cases by 2 separate judgments, which has not been done in these particular cases. So whether the appeal can be heard on merit.
We'll examine that.
And if the matter is again remanded back, this accused appellant.
We'll issue a short notice of 15 days to you, because this is the, in this you'll have to,
Yes,
opportunity
objection, I have to
of
file.
objecting, if any.
Mandatorily, I have to file.
Okay.
My predicament is if the
No, that's okay. but-
matter is remanded back, he will still be in jail, and the learned trial court
No, we
during the trial
understand,
stage will be very reluctant to
we understand
grant
that.
bail.
We understand that, but still, once we are dealing with a interrogatory application of a bail, we'll have to issue a notice. 2 weeks notice we'll issue. Have to say Ganguly Leonard Counsel for the applicant, as well as Mr. R. Kaushik Leonard ABB for the state. Next para. Issue notice on this interrogatory application under section 2. There will be 2 days delay again, because this was filed when 15 May 24. The amendment came in July. That what you call, the new act came into force when?
July.
First of July.
July. So it will be still 389 only. Okay.
Just file prior.
Okay, by this application under section 389 CRPC, the petitioner, the applicant is praying for suspension of the sentence passed by judgment and sentence dated 16/2/2018, passed by the learned Sessions Judge from Calcutta in Sessions Case number 131 of 2014, by which the applicant was convicted under section 302 public 149 IPC and sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000 each. No, 10,000, only 10,000 each is not 10,000. And in default to undergo rigorous imprisonment for 3 months. Post on. In respect of commission of offense under section 147 IPC, the please come again in your cost title. You say 302 public 149, 10,000 life plus 10,000 in default 3 months. Sentenced him to pay fine will be 3,000 under which provision? Or
Under
147?
section 147 IPC.
Okay. Under 147, he was convicted under 147 and sentenced to pay a fine of rupees 3,000 with default stipulation. The applicant was also sentenced for commission of offense under section 148 IPC to the extent of fine of rupees 5,000 with default stipulation. And he was also convicted under section 323 IPC and sentenced to undergo sentenced to pay a fine of rupees 5,000 with default stipulation. Next, issue notice. The state returnable give a date after 3 weeks. And return was so and so. Objection, if any, by the state, may be filed by then. List on so and so. 23rd May. And in this will deliberate and pass orders for notice, issuance of notice. Any other interrogatory applications are pending? No.
All the accused persons are on bail. Only this appellant and there is another person. Okay.
Single bench, item 1.
Yes, service is complete. Good. Yes. Yes,
Lordship, see the order dated 24/10/2024, my lord.
24/10/24.
24. A small issue, my lord. Whether the examination of witnesses done so far should be read in the presence of the petitioner or for a clarification as to whether the cross examination would be on the basis of examination already done so far. So your lordship has permitted them to file written statement. So written statement is not filed, then we file a review, my lord. And now because of this, my lord, we are not able to proceed, my lord.
You have heard her.
But the date may be given, my lord, but short date, my lord.
Next week,
Let it be on 6th, my lord.
6th.
6th.
So 6th, we already have a matter fixed. We take it up on 7th.
Yes, 7th, my lord.
I am looking for private restaurant number 5. Out of station on them, they might be on.
8th, my lord. Then.
5th of May.
Yes.
We'll take it up on 5th.
Yes.
Yes. Mhm. All sides are duly represented.
Yeah, ma'am. Last order to change to that.
Mrs. R. Begum, learned counsel for the review petitioner. Place for adjournment. Where is allowed? Next one. Also. Consent taken from all the appearing counsel and public senior counsel. Next date of listing is fixed on 5/5/2025. So list accordingly.
Obliged.
Item 2 also same.
I think same.
Yes, sir.
Same.
Same. Separate orders. So that.
I think your lordship only for this matter.
No, because it's a chain reaction. This is the third bench today. First division bench had to rise early
Right.
for the second division bench. Second division bench was over, then there's the third division. So now I'm regretting that we could have extended some time for the first division bench. But now I can't call back the time.
It's time was around 4 o'clock, my lord.
Huh?
4 o'clock, my lord.
4 o'clock is otherwise peak working hours. How's everything? Your health? Everything is fine.
So, madam, around 95% okay, my lord, but 5% still to be recovered, my lord. So, of course, I think that time will heal, my lord.
Hmm?
Time is a big factor.
I will take care of that. That's true. Okay.